Welcome to the appendix, where we read the primary sources of the past so that the present can be better understood. Today's primary source: fundamental law in the British Constitution. Letters of the Massachusetts House of Ministry, January 1768. These addresses to the British ministry were part of the protests of the Massachusetts General Court against the Townshend Acts of 1767. In January 1768, the Massachusetts House drew up a long letter to the Massachusetts agent, Dennis D. Brett. Addresses to Shelburne, Chatham, Rockingham, Conway, and Camden, the Lords of the Treasury, a petition to the King, and a circulatory letter to all other American colonies. All of these documents were drafted by Samuel Adams. The extracts given below present one of the earliest formulations of the doctrine of fundamental law in the British Constitution. The theory that Parliament could not pass acts contrary to the fundamental law became a basic theory in American constitutional law. The addresses of the House are given in full in Bradford's Massachusetts State Papers. 1. Letter of the Massachusetts House to the Earl of Shelburne, January 15th, 1768. There are, my lord, fundamental rules of the Constitution, which it is humbly presumed neither the Supreme Legislative nor the Supreme Executive can alter. In all free states, the Constitution is fixed. It is from thence that the legislative derives its authority. Therefore, it cannot change the Constitution without destroying its own foundation. If, then, the Constitution of Great Britain is the common right of all British subjects, it is humbly referred to your lordship's judgment whether the supreme legislative of the empire may rightfully leap the bounds of it in the exercise of power over the subjects in America, any more than over those in Britain. 2. Letter of the Massachusetts House to the Marquis of Rockingham, January 22nd, 1768. My lord, the superintending power of that High Court over all His Majesty's subjects in the empire, and in all cases which can consist with the fundamental rules of the Constitution, was never questioned in this province, nor, as the House conceive, in any other. But in all free states the Constitution is fixed. It is from thence that the Supreme Legislative, as well as the Supreme Executive, derives its authority. Neither, then, can break through the fundamental rules of the Constitution without destroying their own foundation. 3. Letter of the Massachusetts House to Lord Camden, January 29th, 1768. If in all free states the Constitution is fixed, and the supreme legislative power of the nation from thence derives its authority, can that power overleap the bounds of the Constitution without subverting its own foundation? If the remotest subjects are bound by the ties of allegiance, which this people and their forefathers have ever acknowledged, are they not by the rules of equity entitled to all rights of that Constitution, which asserts and limits both sovereignty and allegiance? If it is an essential unalterable right in nature, engrafted into the British Constitution as a fundamental law, and ever held sacred and irrevocable by the subjects within the realm, and that what is a man's own is absolutely his own, and that no man hath a right to take it from him without his consent, may not the subjects of this province, with a decent firmness which has always distinguished the happy subjects of Britain, plead and maintain this natural constitutional right? Thank you for joining us for our primary source today on the appendix. We will see you in the stacks.